Mr. Mashulak, please proceed with the rebuttal.
Thank you. Good afternoon again. There is only, again, I will be giving hopefully a short presentation followed by Professor Newcomb. There's only really 4 points I want to make, which are perhaps more factual in nature than the legal interpretation. The first is that in response to what El Salvador has argued, it says, well, my first point is that Claimant's interpretation of the treaty is not at all at odds with the interpretation of the United States. I disagree with the premise and the argument that they just made. I don't know what's proper and improper in these proceedings, but in the interest of transparency, less than a month ago, received a call from our State Department indicating that opposing counsel was down there asking them to put an opinion on the thing. And would I like equal time? So we both had equal time. I went at a later time. We both had equal time to relate our views to the State Department. The United States has chosen not to make a submission in these proceedings at the end of the day. As to the other 2 states that have in connection with these proceedings, it doesn't escape notice looking at the Dewey and LaBeouf website that their law firm is representing those 2 countries. So to sit here and listen with, in all fairness to my clients, that everybody else in the world is against us, our interpretation of the treaty, it's just plain not true. When I listened to the presentation again this afternoon, I mean, this is derived from language, from snippets of opinions that do not relate to the particular facts before you or the particular issue before you, and that is whether or not we had to discontinue local proceedings before we could even think about filing a CAFTA proceeding. The comment was made, and also a lot of commenting was made suggesting that we did something once we gave our waivers to somehow upset it. We did nothing. The real complaint is that we did nothing, that we did not file something with the court down there. I agree. That's factually true. Did we do something to promote proceedings down there? No, we did not. Did we, what was our mindset at the time? Our mindset at the time, again, is we received correspondence from El Salvador saying that no matter what you do now, you have no jurisdiction and we're going to fight you on that point. And everything that they've said here today suggests that if we would have done like they say, dismissed, and then tried to dismiss the local proceedings and then refile a CAFTA, we'd be into a big statute of limitations fight. I mean, it's more than ever before clear to me today that perhaps that was the object at the time. I would agree with Mr. Smith that El Salvador was never required to teach us, our law firm, international law on the subject. And the correspondence that we received was telling us what their interpretation of the law is. But I believe today, even more so than I've ever believed it before, that our interpretation of the law is correct. That we followed the plain language of the treaty. We did that what was required for us. We gave them a waiver that they could have presented anywhere in the world they wanted. They say this is unfair to a state, that how is a state supposed to know? We told them in our notice of arbitration where the pending litigation was. And then within a month after filing, they're in touch with the clerk of the Supreme Court, but never once raised the issue of the fact that they have the waiver. In fact, I'm glad we did not follow El Salvador's advice, because I think we would be in a very poor position here today. Lastly, the last point is this. El Salvador complains that this preliminary objection proceeding is very expensive to them. Well, it's expensive to us, too. I mean, we're not a huge company. Professor Newcomb didn't get to that point in the presentation, but we would like to recover the costs that we've expended in addressing a motion which we don't think that we acted perfectly proper on in terms of presenting them with an exact waiver as required by the treaty, and and then having them tell us that's not enough, something beyond the language of the treaty is required, having to fight that and hopefully prevail on that issue. Thank you very much.
The all-important watch.
Sure, but don't worry about the watch for the time being, because the tribunal has 3 questions for you. If you might, unless you would like first start the rebuttal.
I believe I better obtain my copy of CAFTA before the questions start. If that.
And I would invite you also to take a copy of, I think, your response.
Yes, Mr. President.
Okay, could you please go to paragraphs 80 and 81 of your response?
Yes.
In paragraph 80, you start to say, the only measures at issue in the domestic proceedings, both capitalized, were the revocation of the environmental permits.
So,
And then you go on, and they say the claimant's notice of arbitration identifies a series of other measures that breach CAFTA and foreign investment law.
my apologies, Mr. President. Are we in the response or the rejoinder?
The response.
At paragraph
80.
8. Thank you.
Yes, yeah.
My apologies.
Okay, the question again. What you see here is in the first 2 sentences, it's stated in the claimant's response, the only measures at issue in the domestic proceedings, both capitalized, were the revocation of the environmental permits. The claimant's notice of arbitration identifies a series of other measures that breach CAFTA and the foreign investment law. And then it goes on with, first, the respondent decisions not to renew the claimant's exploration license are undoubtedly measures. And then if you go in 81, there's the second one. It says, second, the notice of arbitration claims that the respondent has imposed a de facto ban on gold and silver mining, which is arbitrary, discriminatory and expropriatory. Could you help us? Where do we find those 2 points? Of those 2 measures complained about in the notice of arbitration, in the sense that they are presented as a claim in this case. So let's take them in turn. So first you have the respondent's decisions not to renew the claimant's exploration license.
Paragraph 24 of the Notice of Arbitration says that on January 29th, 2009, Commerce and SAMSEB's legal counsel filed a challenge in the...
Sorry, January 20 it says. This is my copy.
January 20th,
Yeah.
2009. Commerce and SAMSEB's legal counsel filed a challenge in the courts to the government's refusal to honor Commerce's SAMSEB's request to extend its exploration permits pursuant to the terms of the 2002 permits. So those are the measures with respect to.
Were that not the proceedings that had already been resolved, or am I confused here?
There, as clarified later, or clarified by the respondent in its, I believe, their preliminary objection, that there were never any legal proceedings with respect to the exploration permits. There was an administrative review process, an internal administrative review process, but not legal proceedings before the El Salvadoran Supreme Court in the same way that there was with respect to the revocation of the environmental permits. So the reference to these legal proceedings have not been resolved is not factually correct.
But
Yeah.
yeah.
In the sense the administrative review process is a legal process, but with respect to the question of application of the waivers, internal review process, or our submission is that internal review processes are not caught by the waiver requirement.
But could you help me? Is down whether or not proceedings have taken place about the exploration permits? Are they measures complained about in notice of arbitration? Where is it that you complain about them in the notice?
In paragraph 23, it says that on October 10, 2006, Commerce applied to MARN for an environmental permit for its exploration in connection with the new San Sebastian exploration license and the Nueva Esparta license. MARN did not respond to the request, and on March 8, 2007, Commerce Sanseb applied to the El Salvadoran Ministry of Economy for an extension of these exploration licenses, as was its right. On October 28, 2008, the Ministry of Economy denied Commerce and Sanseb's application, citing Commerce's and Sanseb's failures to secure an environmental permit. That was an environmental permit with respect to the exploration licenses.
But you see, if I look at paragraph 80 of your response, you say, but the notice, you say that the claimant's notice of arbitration identifies a series of other measures that breach CAFTA.
Yes.
And then you say the first one is not to renew claimant's exploration licenses.
Yes.
And really what I'm looking for is a place where you can find that indeed this is a measure referred to as a breach of CAFTA.
In paragraph 26, the claimants refer to the government's ban on development of gold and silver mines applies in practice exclusively to foreign companies, and A, the government of El Salvador asserts that the current ban on mining and silver mining and exploration connected with this mining stems from the government's desire to protect the environment, the government permits, and other activities. So there's
Más despacio. Slower, please.
in paragraph.
Can you please repeat it? Because what you're saying is that paragraph 26 contains an identification of a measure that breaches CAFTA. And as the first one identified in paragraph 80 is not to renew the claimant's exploration licenses. And
Yes.
26 talks about, at least the opening, about a policy as applied that would discriminate against foreign investment. Could you please help me with how I can connect the two?
Paragraph 26A says that while the government of El Salvador asserts that the current ban on gold and silver mining and exploration, so there's a reference to the fact of the current ban on gold and silver mining. We then turn to B, the government's ban on the development of gold and silver mines, and that ban on the development of gold and silver mines, we say, is a de facto moratorium or practice, and this would include the decisions, regulatory decisions, not to approve exploration licenses, not to approve permits, environmental permits, and then in paragraph 30, there's a reference by its conduct referring to the government's ban on development of gold and silver mines, which includes the exploration licenses. I accept that there's the notice of arbitration does not set the issue out clearly with respect to exploration licenses, but our submission is that it is pleaded that there was one of the measures complained about is the denial of the exploration license in paragraph 23. We're saying that this is in paragraph 26. We're saying that this is a policy or a practice that discriminates against foreign investment, and further in B elaborated as a ban on development both of exploitation concessions and exploration licenses. The policy that's being referred to is the sort of the de facto moratorium. Paragraph 27 refers to this policy, and I would read that as this measure or this conduct as applied is arbitrary and rational and has denied commerce of its property rights. And then paragraph 30 pleads the reference to by its conduct in reference to all of the previously enumerated paragraphs. By its conduct, El Salvador has breached these obligations: national treatment, MFN, minimum standard of treatment, and expropriation.
Then I have, if everyone has a further question. Now the Supreme Court has rendered a decision on the environmental permits. Does that decision have any effect, either legally or factually, in the present case?
Clearly, it has an effect factually. It is an act of the Supreme Court. One of the there's issues of minimum standard of treatment in the claim, but the Supreme Court judgment made a determination that the revocation of the environmental permits was in accordance with the law of administrative procedure in El Salvador, and so we have a final determination of the highest court in El Salvador that there was compliance. And so there's a sort of a final determination of the court on that issue, and that may have some type of res judicata effect with respect to factual determinations of El Salvadoran law. But the main claim in the arbitration is that there is a de facto moratorium on gold mining, despite the fact that the claimants have a concession which runs until 2034. In practice, as a measure, the government is not issuing any regulatory approvals, and the acts since 2006, including the revocation of Commerce's permits and the exploration license, is background to that main claim, in addition to the other additional claims that are are submitted.
Now, let's now hypothetically, for law professors that's always a wonderful exercise, let's now hypothetically reverse the situation. And let's assume now that the Supreme Court would have granted the relief sought by the claimants.
Yes.
How would that have had an effect, if any, on the present proceedings?
The claimant's submission is that the effect of the waiver is definitive, and that with respect to there's a waiver of rights to continue and initiate proceedings with respect to the environmental measures. The claimant's submission is that if there had been a final determination in favor of Commerce that there was a breach of El Salvadoran law, and that Commerce was awarded $100 million, that the waivers would be operative and legally definitive to extinguish and abandon any right that the claimants had to the benefit of that judgment, or to initiate proceedings, because we also waive the right to initiate proceedings with respect to any enforcement, because of course there's a court judgment that says El Salvador must pay $100, but if El Salvador doesn't comply with that, there would still have to be enforcement procedures. And our view is that the waiver, given its definitive effect and wide effect with respect to the measures at issue, would include anything. So that goes back to the position that the waivers provide a complete release to the state with respect to any legal rights that the claimants might have with respect to those future proceedings. Once the waiver is submitted, those proceedings from the point of view of the claimant are essentially, I'm not sure what the exact word is, but that the idea is that the claimants would never be able to obtain any benefit from a favorable judgment, given the waiver having definitive effect.
But would it then not work also in the same way with regard to the previous question of the tribunal? What you are saying now, as I understand, is the waiver operates as an obstacle to giving any effect to the Supreme Court judgment in case it would have been in favor of the claimants. Does my understanding is correct?
Yes.
Would it then also have been an obstacle in respect of the situation that actually occurred, that they rejected claimants' relief? That also has no effect whatsoever.
It has no effect for the purposes of El Salvadoran law, but the claim, the CAFTA claim.
No, also let's backtrack. Assume now you would have won in El Salvador. You were the claimants. Could you still pursue the claim in the present case?
Yes. Because the claimant has complied with the jurisdictional requirements in the waiver. The win in El Salvador is a determination with respect to whether the revocation of the environmental permits were valid under El Salvadoran administrative law. They don't make any sort of determination with respect to CAFTA breaches, and the claimants would be able to, in our submission, be able to continue to make submissions with respect to the breach of CAFTA obligations based upon the revocation of the environmental permits.
see. Still, the tribunal has some questions in the hypo that the claimants would win in El Salvador, and your submission is that you could not collect, being the claimants, on the judgment in El Salvador because of the waiver. Is that correct?
Yes, that's correct.
But how does it work? Because the Supreme Court has issued a decision, and in you completed the hypothetical by saying, "No, let's assume that we got our 100 million in damages." That's not only because you was also at the same time were claiming damages in that proceeding.
Yes,
correct?
yes.
Assume now, and now, how does it operate? So you basically you could collect the judgment, and how does it operate that under Salvadorian law? Could then the respondent say, "Wait a moment, you waived your right to continue the proceedings."
Yes.
You could, and now I go on. You can say, "Wait, proceedings are over. I have now a judgment against you." How does that operate under Salvadorian law? You can simply, could then the respondent say, "Well, no, here I have a waiver of you," whereas there's already a judgment by the Supreme Court?
Mr. President, I'm not a licensed attorney in El Salvador. We do not have El Salvadoran law on that question of what the effect would be. Our submission, given our view that the waiver is a complete extinguishment of all legal rights, any legal rights with respect to those proceedings or benefits from those proceedings, that there is just absolutely no opportunity for the claimants to obtain a benefit. And our submission would be that the Attorney General would be able to submit the waiver to the courts to show that there had been this complete abandonment of rights, as was done in the Vanessa Ventures case.
I assume he has not done so. Then the Attorney General has waived from his side the right to invoke the waiver. Is that your position? Because it gets now complicated, and all this would not have happened if, one way or the other, before the judgment had been issued, somebody had told the court, "I think you should stop because there's now the proceedings have been relocated to an international arbitration, and we have here a waiver."
We go back to our fundamental submission that CAFTA does not prevent or prohibit concurrent proceedings. The mere fact that if the El Salvadoran Supreme Court had issued its judgment on June 30th, and then claimants had commenced arbitration on July 2nd, there would be no issue. So the mere fact that there is a definitive judgment of the El Salvadoran Supreme Court with respect to the revocation of the environmental permits, that is not a problem for the purposes of the CAFTA arbitration.
Let's not further complicate the hypo, because we're not talking about proceedings that have ended before
Yes.
The 2nd of July, 2009. And we're talking about something what still is going on the 2nd of July, 2009. And there we wonder how this works if you do not take any step in those proceedings because of the commencement of the arbitration. But what then may happen is that you are running on two parallel tracks. If somebody does not say, wait a moment, stop here.
Yes, and our submission is that respondent states in some situations may want, after having engaged in 3 years of litigation, to have a resolution of an issue such as this determined, and that there's nothing in CAFTA that prevents that. What if this was, for example, test litigation, and this was one claimant, and there were 100 other claimants in the similar situation in El Salvador? The state might have an interest in having a definitive resolution on this issue that would then would be useful for the state. So it goes back to the submission that the fact that there was a final decision of the Supreme Court on a specific matter of El Salvador administrative law is a fact, but that it doesn't, one, affect the jurisdiction of this tribunal, and this tribunal can proceed to make determinations of whether El Salvador's conduct breaches CAFTA obligations and the foreign investment law.
Thank you. After you have finished your rebuttal, we would like to ask also the respondent to comment on this question, if they wish so. Because, unless you would think that the respondent should already now comment on this question, then we can dispose of it now, if that's procedurally proper. But now we are really deviating from the beaten path of you and now the rebuttal.
I'm in your hands, Mr. President. If Mr. Smith would like to address the question now, that is fine with me. Or
Mr. Smith, if you would like to, I think we have to finish this question, if at all you are in a position to do so.
Okay, I think I can.
You can. There you go. Michael.
I guess I can respond from here if you don't want to. I need to.
please.
I can turn on this one. I think the hypothetical has become somewhat complicated, but I guess the question is, or part of the question is, at least, is what would be the effect on this proceeding, and particularly with regard to the waivers, if the Supreme Court of El Salvador had decided in favor of the claimants, issuing them an award for $100 million. The claimants take the position that they would have, because of the waivers, they would have no right to collect on that award, and that they have renounced all rights. A first point to make is I very seriously doubt that had the decision gone their way, that they ever would have taken the position that their waiver prevented them from collecting $100 million. That is a position that they can take now because it is coherent with, in some sense, with their position on the waiver. But if the case had gone the other way, I would find it very surprising if they would interpret their waiver to that extent. What would the effect have been on these proceedings? The measures at issue before the Supreme Court of El Salvador were the revocation of the environmental permits. Those are the measures that give rise essentially to 100% of the claims of the claimants. At the time that their environmental permits were revoked, they lost their right to their concession. Every right that they had in El Salvador was ended. Nothing that would have happened after 2006 when they lost those permits could have caused them any further injury. They have no claims for measures taken by the government of El Salvador other than that. So just let me finish. So if the Supreme Court of El Salvador has decided that those measures were invalid and issued an order for compensation, there would be no further issue in this arbitration.
Let me ask you then one step further. The hypo was that indeed, as you stated, that the claimants would have prevailed in the court case. And then the question was, under Salvadorian law, could you invoke the waiver? Now, there are two aspects to this. First of all, a procedural aspect, because you have already a judgment against you. And is there still a possibility then to invoke the waiver? And the second one is, even if there's a possibility to invoke the waiver, since you have previously taken the position that the waiver is invalid, can you then still say, well, wait a moment, after all, I have now second thoughts about this, the waiver is valid?
A decision of the Supreme Court of El Salvador would be binding on the government of El Salvador. The existence of the waiver would not be something that the government could, as a legal matter, use to oppose the enforcement of a binding judgment of the Supreme Court of El Salvador. The government would be obligated to pay the award because it is an award of the highest court of the government.
Thank you. That's okay. Dr. Nolan has some question.
I'm sorry, is that a statement of counsel, or is there any authorities behind that? Because this seems to be an important issue, and the same, my question is also to attorney to the claimants. Whatever you have said regarding the effects of the waiver, is that your position, or is that supported by some authorities, precedent? And the question goes to both parties, because I've seen assertions in one sense and the contrary assertion on the other, and I want to know, legally speaking, where we stand under Salvadorian law.
Let's first start with the respondent on this one.
Okay.
Then we finish this one, because we actually in rebuttal time.
Right. Okay. Simply, we have conferred with a representative of the Attorney General's Office of El Salvador, and that was the opinion he related to us. It is not based on a review of court cases or decisions. If the tribunal would like further documentation on this issue, we'd certainly be willing to provide it.
Please also finish this point, and then you can start your real rebuttal.
Our submissions with respect to the waiver in El Salvador are submissions that are not based on, we do not have legal opinions of local counsel in the materials. One point, however, is that if we're thinking of the waiver, it's sort of, one question is sort of what is the law that applies with respect to the requirements for the waiver, and my submission is that the effectiveness and requirements for the waiver, must they not be determined by international law? Why is it that El Salvador law is controlling, particularly where the waiver requirement applies in different CAFTA parties? And so why are we so focused on El Salvadoran law? Our submission is that CAFTA as an international treaty requires a certain form of legal document to be provided. And it was provided in accordance with CAFTA. So really, in some sense, and I know there have not been submissions on this, the question seems to be more about whether the waiver is effective under as a matter of sort of treaty interpretation under international law.
The question is not so much about the waiver in and of itself. The question is how you can procedurally invoke it once the Supreme Court has issued a judgment.
Yes.
And is there a procedure in place then to invoke the waiver? And then especially because this is an added aspect to this is that it may well be that the party, that in this case Salvador in the hypo, cannot invoke the waiver because they have previously taken the position that the waiver is invalid.
Yes, I understand. The additional issue I would suggest is in many court procedures in many countries, there's an opportunity to apply for a revision of a Supreme Court judgment. So to the extent of a court decision based upon information that was not before the court at the time. So if the court did make a decision, a final decision in favor of the claimants, again, would it not be available to the Attorney General to make a submission for revision of that decision based upon new information that was not before the court? And I would submit that in most domestic court procedures, that procedure is available and would be effective, and you'd have a similar situation that we had in Vanessa Ventures, where the Constitutional Chamber of the Venezuelan Supreme Court dismisses the action based upon the waiver.
Thank you for all these answers. You can now proceed with the
Thank you.
rebuttal.
Mr. President, members of the tribunal, in light of the time, I will try to use the utmost economy in making my submissions brief. My next submission from this morning is the point that San Sebastian was not a party to the domestic proceedings. The record in the domestic proceedings is clear that only Commerce was a party to the proceedings. The court judgments highlight that the environmental permits were issued to Commerce. The Marne resolutions in question revoked Commerce's permits. The notifications refer to Commerce as the party. The judgment only refers to Commerce. My submission is if San Sebastian had sort of moved to discontinue the domestic proceedings, the court's response would have been clear. San Sebastian was not a party to the proceedings. Now,
you are now on slide 57 of your presentation.
Yes, I'm on slide 57. The fact that the claimant's lawyers identified himself as the attorney for both companies, which operates as a joint venture, we submit is not relevant to the question of whether San Sebastian was a party itself to the domestic proceedings. Further, the claims by San Sebastian in this arbitration are as San Sebastian as a separate entity which has an investment in the joint venture. Investment in CAFTA is defined to include sort of an equity participation in an enterprise. And an enterprise is defined in CAFTA to include a joint venture. Sanseb's investment was its participation, its ownership directly and indirectly in the joint venture, and also San Sebastian had separate investments in El Salvador, including the lease on the mine. The point is that in this proceeding, the claim is not being made by the investor on behalf of an enterprise in El Salvador. This is not a claim where Commerce is claiming on behalf of the Commerce Sanseb joint venture under Article 1016.1b of CAFTA. There's the provisions about claiming as an investor in your own right and claiming on behalf of the enterprise. So the question is not, the issue is not about whether Commerce was acting on behalf of the joint venture in the domestic proceedings for the purposes of CAFTA. For the purposes of CAFTA, San Sebastian is an independent investor with an investment which includes an equity participation in the joint venture. It's claiming for damages for the effect of El Salvador's measures on its investment, and its investment is the equity participation in the joint venture, plus its separate investments which it contributes to the joint venture. So in response, our submission is that SANSEB the waivers did not apply to SANSEB, and the court record makes that clear. Finally, with respect to the tribunal's jurisdiction with respect to the foreign investment law issue, I would just highlight that the claimant's notice of arbitration requests arbitration both under CAFTA and Article 15 of the foreign investment law. There is an issue with respect to the particulars claimed by the claimant with respect to the breaches of the foreign investment law. Respondents this morning have raised an issue about whether there was consent. We submit that there is consent. I would just note that the issue of sort of whether there is jurisdiction with respect to the foreign investment law was not really an issue that was pleaded in the preliminary objection. And my understanding with the preliminary objection was primarily focused on the issue of whether there was consent under CAFTA. Of course, we do submit that there is the separate consent to arbitration under the foreign investment law. With respect to the issue of ancillary claims, we claimants submit that if the pleading just with respect to naming the foreign investment law is insufficient, that we claim to make an ancillary claim with respect to certain breaches, and that we rely on various authorities on ancillary claims, including in Enron. I would note, and this is in Professor Schur's commentary, which has not been submitted as a legal authority, although with permission I would submit it, that in Enron the tribunal decided to accept the new request for arbitration as an ancillary claim. So to the extent that there are deficiencies with the notice of arbitration, our submission is that based upon ICSID rules, based upon the convention, that we can submit an ancillary claim to address any of those deficiencies. Further, with respect to the foreign investment law, the waivers do not prevent the claimants from bringing claims in this arbitration based on the foreign investment law. The CAFTA waiver is a waiver of a right to bring another separate proceeding under another dispute settlement procedure. There are not two proceedings in this case. In this case, we have one proceeding based on two consents to arbitration, in which the CAFTA is making claims both under CAFTA and the foreign investment law. And we submit that the PACRIM decision on this is persuasive. The whole purpose of the waiver requirement is so that there's not concurrent proceedings. So the whole purpose is to ensure that claims are brought in one form.
Sorry, may I just ask a question about
Yes,
this?
Mr. Thomas.
The question I have relates to the structure of Article 10.18.2, the last limb, where we get into the waiving of other procedures. And I think, I take your submission to be that under the foreign investment law, the consent to exit arbitration there would allow the claimant to bring before this tribunal claims in respect of the revocation of the environmental permits.
Yes.
Is that correct?
Yes, it is.
Okay. If that's correct, I just draw your attention to the use of the wording any proceeding with respect to any measure alleged to constitute a breach. And the question I have for you is, how do you differentiate, when we're talking about the environmental permits revocation, how do you differentiate between a cause of action based on local law, municipal law, a cause of action based on the foreign investment statute, and a cause of action based on the treaty? Where do you find the right to have a different cause of action in respect of the same measure? This is what I'm having trouble with in your argument. Just to be absolutely clear, isn't the focus here on the measure? If the measure has been challenged in a claim for damages in whatever forum captured by that language,
Yes.
isn't that what the tribunal should be focusing on the measure as opposed to the cause of action which gives rise to the claim?
Thank you for the clarification. Our submission is that if the claimants commenced a separate arbitration proceeding under the foreign investment law, that the waiver would apply. Because the references to any proceeding with respect to any measure. And in the context of any proceeding, the focus is on proceedings other than the CAFTA arbitration. And that there is only one proceeding. There's only one ICSID proceeding. And that the waiver would not apply when the foreign investment law is brought into the same proceeding. And it goes back to the whole purpose of Article 1018 is primarily with respect to ensure that there's not concurrent proceedings with respect to the same measure and all the difficulties that arises. In this case, there'll be one tribunal making the determination. Therefore, there's not concurrent proceedings. There's no problem with respect to concerns about inconsistent decisions or double recovery. And in our view, the PAC RIM decision supports that interpretation.
Sorry, just this is just the last question on this point.
Yes,
because I know but the provisions of the CAFTA which provide for the submission of a claim to arbitration list what can be alleged to be at issue in the arbitration in Articles 1016, and they only refer to either an obligation under Section A or an investment authorization or an investment agreement. They don't refer to any other legal regime that can be the subject of a CAFTA claim.
No, but this proceeding involves both the consent to arbitration under CAFTA and the consent to arbitration under the foreign investment law. The reference to if I may say that this, with respect, in Article 1018.2, the provision says, at the very last, any right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedure, any proceeding with respect to any measure. Now, it's not any claim with respect to any measure, right? If it was any claim with respect to any measure, then the idea would be that you can only bring CAFTA claims, but the focus is on any any proceeding. So you waive the right, and the waiver of the right only extends to other proceedings. But within the CAFTA, within this arbitration, which is one proceeding, any type of claim based upon consents in other instruments can be brought.
Thank you.
Finally, just with respect to the foreign investment law issue, I would just highlight the respondent argues that the waiver the claimant's waiver is effective with respect to the foreign investment law claims, which we of course reject. But of course, at the same time, they're also saying that was not effective vis-a-vis the domestic proceedings. In our view, the waiver is effective with respect to the domestic proceedings, but does not prohibit to have one proceeding involving two consents. I will now turn to just a number of the of questions and issues in response. With respect to the tribunal's question with respect to the dissenting opinion of Mr. Hyatt. In the response, we do not suggest or claim that Mr. Hyatt's dissenting opinion is authoritative as a statement of the meaning of the decision of waste management. We refer to the decision of Mr. Hyatt to highlight the treaty a point about treaty interpretation, which he makes about if NAFTA had contemplated the termination of domestic litigation as a jurisdictional requirement, well, you would have expected the treaty drafters to have that express requirement. So it's more to just highlight and draw upon our argument about treaty interpretation. Second, we refer to Mr. Hyatt's dissenting opinion for the principle that there is the distinction between jurisdiction and admissibility, and that post-waiver conduct is an issue of admissibility. Our submission is not that Mr. Hyatt's dissenting opinion was the correct determination of the case. As I submitted this morning, our submission is that the majority of the Waste Management Tribunal was correct to find that there was no jurisdiction, because in that case there was a defective waiver, because at the time of submission, because the investor in that case carved out something from the waiver, and it was not effective. Clearly, I would agree that dissenting opinions in international arbitration are they're clearly not binding, depending on the strength of the reasoning. They may be persuasive in certain circumstances, like any other legal authority. With respect to the issue of whether there's an agreement between the CAFTA parties with respect to the interpretation of CAFTA, I would highlight that the various statements of the CAFTA parties, which have been referred to by the respondents on the requirement for conduct, focus more on the question of the requirement for conduct consistent with the waiver. So most of the submissions, for example, the U.S.'s submissions in Tembec argue that the claimant's conduct subsequent to the waiver can negate the waiver because of post-waiver conduct. In this case, the interpretive issue is with respect to whether there is a requirement to discontinue prior to submitting a notice of arbitration. And there's the various statements of the CAFTA parties are primarily addressing the post-waiver conduct issue. They're not addressing the specific treaty interpretation issue. So there clearly is an agreement on that issue, and there is because primarily the CAFTA states are referencing post-waiver conduct. Finally, CAFTA provides an express procedure for binding interpretation provisions, and that has not been used in this case. On the question of could El Salvador have discontinued the proceedings, the respondents have submitted this morning that the respondents were powerless to have the domestic proceedings dismissed. First, we would note that El Salvador never requested the claimants to take the active step to discontinue the proceedings. The respondent never notified the court of the waiver. Respondent suggests that only claimants could request termination. However, the Attorney General's opinion only addresses the submission that came in on Friday only addresses whether the claimant can discontinue the claim. And we agree that there is the possibility of the claimant discontinuing the claim. The Attorney General's opinion and those materials do not address the question of whether it is impossible for the Attorney General to have the proceedings dismissed with the waivers in hand. We would note that Article 40 of the Law of Administrative Litigation refers to discontinuance by the claimant or discontinuance of the claimant. And it's not clear why the waiver could not be considered itself a discontinuance by the claimant. In the claimant submission, the material before the tribunal does not prove that there's just simply not evidence before this tribunal that El Salvador was powerless. What the materials establish is that the claimants could have discontinued, but there is the point is not established that the respondent could not have submitted the waiver to the court, again, as was done in the Vanessa case. Mr. Smith made the point that the waiver includes the requirement to act in conformity. The difficulty with this submission is that it then means that jurisdiction is not determined at a particular date, because if the waiver includes the requirement to act in conformity with the waiver, well, then we have a sort of a situation not where jurisdiction is determined on the date of the submission of the notice of arbitration, but a situation where jurisdiction sort of floats in the air, and it then depends upon the subsequent conduct of the claimant. And we submit that this is not the regime that is established by CAFTA. Jurisdiction is determined as of the date, and there is no sort of post waiver conduct is irrelevant to the jurisdiction of the tribunal. Mr. Smith suggests that our submission is that the claimant has the obligation to do nothing and may initiate proceedings everywhere. That is not our submission. Our claimant's submission is not that they can engage in an abuse of process. We've been very clear that the tribunal has a supervisory mechanism to ensure that claimants do not act in good faith. The claimants accept that the claimant has an obligation to arbitrate in good faith, that the tribunal can control the use of waivers. But the submission is that there simply is no bad faith in this circumstance. There was never a request to discontinue, and the Attorney General's position was in his letter to ICSID that whatever the claimants did, it didn't matter. It was pointless because jurisdiction was lost. In conclusion, the claimants submit that CAFTA Article 18.2 should not be interpreted to read in a restrictive jurisdictional condition. The claimants fully satisfied the jurisdictional requirement. The claimants submit that the preliminary objection must be rejected in its entirety with cost to the claimants, and the claimants respectfully request that the tribunal grant the relief requested in the claimant's response at paragraph 101. I will now conclude unless there are any further questions.
Tribunal has no further questions. Thank you, Professor Newcomb.
Yeah, thank you. Those are my submissions.
This concludes the rebuttal by the claimants. We said there was liberty to apply before the lunch break. I see Mr. Smith looking with some consternation.
I would like the opportunity to reply briefly. I assure you I will be brief, but I would like maybe just 1 or 2 minutes to gather my thoughts, if you would.
Okay, we have 2 minutes recess.